if any of you are there, I am scrolling down on Canvas because I can't just, I have to actually hold the arrow key down to try to put the new um, um, live link. So I'll be right back in a second. Yeah, that's my dog barking. Okay. So hopefully if I go back here, yay, there are people. Sorry, I just had to do the, I don't know what it did. I give up on all technology. We'll wait a second for the folks to catch up. And I got a bunch of your questions, and I will go through those. And someone asked me to go through, the PowerPoint from a couple days ago. So let me find that while I'm, where it said there were like, and I'll do it last. Where the heck is it? You have no idea. Okay, hang on. The other day, I did the one that had the first slides were about review. And so I'm trying to find the ones that said the first few slides are for you to do. And I just don't remember the date of it. Okay, I'll have to try to find that. All right. Sorry. The if one of you, I don't remember who asked, somebody asked me to go back through the PowerPoint, and it began, it said the first slides 1 through 10 are for you to review. Is that at eve of trial? Hang on, let me, 3:30. Okay, hang on, let me look. Sorry, I don't know why. Well, so here's the, and by the way, so on the quiz, hang on, I gotta focus or I'll screw this up again. Okay, yeah, is that the one? Yeah, okay, so thanks. All right, sorry for the glitches. So the Canvas, the quiz thing, and I'll go through the correct answers just to deal with it, but there was a place I changed the quiz, and then there's a button I have to push or click that says save changes, and I just push save, and so it saved the old thing. So that's why you got to regrade. But some of you had questions, and it sounded like you were still getting the wrong answer. Even you'd pick the wrong answer, and it was the wrong answer. So let me go through those issues first, and then the questions I got, and then I'll go to the slides. And if you have other questions, text or email. Text would be better because I've got my phone with me, and the text number is 478. Here, I'll type it down. So it's, whoops. And I'll answer those too. But so these are good questions because they also help, I think, better to understand judgment as a matter of law, and why you would want the judge to deny a 50A motion. And so let me begin though with the questions. The Chamberlain case, the question was, did it ultimately end up in the plaintiff Chamberlain getting a new trial? And the answer to that is no. And let me work through it. And this will, I think, help you to understand why the judge normally won't grant a 50A motion, even if he believes or she believes it should be granted, and also why you, as the defendant, don't want the judge to grant the 50A motion if you're right and there is no evidence. If you're losing the case, you're like, hey, please grant it. So let's work through Chamberlain first, and then let me come back through it. So Chamberlain puts on his case, and the defendant moves for directed verdict, 50A. Okay. Now, the judge grants that motion. The trial judge grants that motion. So back in the day, what that meant was the jury was told, go back and click the box that says defendant wins, and 4 persons, actually back then it was 4-man, write your name and the case will go away. Nowadays, what happens is the judge, if they were to grant it on the entire case, you go claim by claim, the judge would say, ladies and gentlemen of the jury, thank you so much for your service. We really appreciate it. We no longer need you. The judge doesn't order them to go back, but the judge also doesn't just suddenly say, have a great day. So now think where we are. We've gone through discovery. We've gone through the trial to the point where at least the plaintiff has rested. And that's the opening of the window for the defendant to move for judgment as a matter of law. And it might even be the entire case, both plaintiff and defendant have put on their entire cases. So at that point, think of the time we've already spent. And all that has to happen goes back, we instruct the jury, they go back, deliberate. And if the defendant is right and if the judge is right, the jury is going to find for the defendant. Okay. Well, what happens in the real case of Chamberlain? The judge grants the 50A motion. Now, what does that mean? That means back then, verdict for defendant. The judge then enters judgment for the defendant, and that means the plaintiff appeals. Appeals take a year or so. Nowadays, probably longer. Back then, probably, well, with things the way they are now, probably even longer. When I was a clerk back in 2013, 18 months by the time trial was over or whatever happened below was over to us processing the case and getting a result back. So instead of waiting a couple of days or one more day for the jury to do its job, the judge grants the directed verdict. The defendant gets the judgment. The plaintiff appeals. A year or so later, the Court of Appeals, in a split decision, says that was a mistake. And let me be really clear. The Court of Appeals looks at the trial record. They don't have another trial or anything. They look at the typed up words from the trial and exhibits and depositions that were used. And the Court of Appeals decides that there was some evidence from which a reasonable jury could find for the plaintiff. So the district court erred in granting a new trial. In granting judgment as a matter of law. So therefore, they ordered a new trial. Go back down, and this time, if everything happens the same way, let the jury decide who should win. Okay, so 18 months later, then you got to wait in line. Now another year later, you're back in the trial court. You do it all over again, and maybe who knows how it's going to come out. We know that it's going to go to the jury this time. Well, again, what happened in Chamberlain? It went up to the U.S. Supreme Court. So another couple years go by, and that court says, no, if you look at the last sentence of the opinion, besides where it says the concurring judges, this is on 633, says the judgment of the Circuit Court of Appeals is reversed and that of the district court is affirmed. And so what does that mean? That means the district court's decision to grant JMOL was correct. There was no evidence from which a reasonable jury could find for the plaintiff. Now, so that's how this case played out. Now, why as the defendant do I not want that motion granted? First of all, to be clear, I have to make a 50A motion or I can't make a 50B motion. And to put it in practical terms, I have to make a 50A motion because if I lose the verdict, the only way I can have it flipped so that I'm now the winner is if I made a 50A motion. You have to make a 50A motion in order for the judge to turn you into the winner under Rule 50B. Okay, so I make the motion, but I expect the judge to deny it, or hope the judge will deny it, even if I am correct that there is no evidence. So now what would have happened let's work through this in Chamberlain. So the correct, let me back up. So the correct answer to the question was it would not have been a new trial. It would have been judgment for the defendant was affirmed. There was no evidence to give a verdict or judgment to the plaintiff in that case. So now let's work through what if the judge had denied the motion? Okay, defendant gets up, says, Your Honor, there is no evidence that the cars hit Mr. What was the name? Bainbridge is speculating the angle. You've got 9 witnesses, blah, 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 all that stuff. And the trial judge says, I believe you're correct. However, I'm going to let this case go to the jury. That afternoon, closing arguments, jury instruction, verdict comes back. And if the jury is a reasonable jury, they're going to say, hey, there was no evidence that the trains hit each other. So therefore, we got to check defendant, and we would have been done. Now, if I'm the defendant, why does that put me in the better place? Because now, before, if there was any evidence, if there was sufficient evidence, more than a scintilla to get to the jury, it's going to be reversed on appeal if the judge grants the motion. Now, if I win the jury verdict, as long as there's some evidence to support the verdict, I'm going to win on appeal. So, I mean, I'm going to win. We will see jury verdicts are very, very hard to put aside. So I go from being able to say, even if you believe Bainbridge guy, there was evidence that the jury believed that there was no hit. I win. So what? There was a dispute between Bainbridge, and I'd argue, hey, he's no evidence anyway. But even if you want to credit Bainbridge, there was evidence from which the jury could find for me, the defendant. So I win. I don't care. That's really easy to defend, as opposed to trying to turn Bainbridge into nothing, right? That's very, very difficult. So now, if the jury comes out the right way, meaning the jury says, you're right, there is no evidence, I'm in a better place. What if the jury comes out the wrong way? Well, then afterwards, I file my 50B motion. The verdict comes in, judgment is entered for the plaintiff. Then I file my 50B motion, and I say, Judge, there was no evidence. That Bainbridge guy, like I said in my 50A motion, and I argued to you, he was speculating. That was no evidence. And the judge can say, you're right. I'm going to now turn you into the winner. And now I'm in the same place that I was in if he'd granted the 50A, right? So what this does is denying it gives the jury the chance to get it right. And if you're wrong as a judge, in other words, and think about that, if there's just some evidence, you're going to get reversed on appeal, and 2 years later, it's going to be back down your court again, and you're going to spend that time then. Okay, so that is why you don't want a judge to grant a 50A motion, even though, again, unless you are losing really badly, in which case it'll get reversed on appeal. But it also explains, I think, the question in the quiz. I hope explains the question on the quiz. Now, the other one that people had trouble with was the question about what's the standard for granting a 50B, and every answer was wrong for sometimes multiple reasons. One of the answers said plain error, and plain error is we'll look at it closely, but the only thing we've seen it so far with is if there's an error in jury instructions. So that answer shouldn't have distracted too many of you. One of the answers said the standard was if the verdict was against the great weight of the evidence. That's only for new trials. The standard for judgment as a matter of law is there's some evidence from which a reasonable jury could find for the non-moving party. One of the answers said that the movement won and then filed a 50B motion, and it said that they didn't have to make a 50A motion. So you have to make a 50A motion to renew under 50B. So that answer was wrong for that reason. And this gets to the core of why you file a 50B motion. The only reason I file a 50B motion is I lost on something. And it can get real complicated. Let's just keep it Chamberlain. The only reason that anybody would file a 50B motion if it had gone to the jury would be if the defendant, the plaintiff can do it, but it's the defendant had lost. They would say, I should get judgment. You should turn the judgment winner into the judgment loser. So if you win, you don't file a 50B motion because you won. The judgment is in your favor. So that's why that answer was incorrect. Um, the other one, and it was again my fault for not pushing the right button. It is entry of judgment, not entry of verdict, and it's just me not pushing save changes. Um, on the There was a couple of questions on the discussion board about the judgment and why you would file a motion and all that, and I explained it there, but let me go through that part because this is just mechanical, and it's kind of understanding can help you understand the practicalities of this. So remember, the significance of a judgment has a couple of things. One is it starts the 28-day, and I sometimes say 30. I apologize. It used to be 30. For 29 years of my career, it was 30, and they changed it to 28, I think. Um, the entry of judgment starts the deadline to file motions for new trial and 50B motions. So I want the judgment entered if I won, so that the other side has to file their motions for new trial promptly. So I want to get that done. If I'm the plaintiff and I won, I want that judgment entered quickly because it starts the clock. But also, once I get a judgment with things called, unless it's stayed by the judge, that's when I can go take it to the sheriff and make the sheriff foreclose on their property and get me money. So the way the rules are structured, it says the clerk or the court enters the judgment. That is true. That could be a year. That could be 2 years. They could forget about it. So what happens is if you won the verdict, the next morning you prepare a proposed judgment. And it's very short, and it's called a separate document just because it's not the verdict. It's just a piece of, it can be a couple pieces of paper, but it's usually just like 1 or 2 pages. And it'll have a caption at the top, and then it'll say judgment. And sometimes it'll say, if you're real good, final judgment. And we'll talk about why you put that. And then it just has a sentence that says, like in Chamberlain, it would say, this case was tried on October 1st, 1953, or whatever the date was. The judge directed a verdict for the defendant, therefore plaintiff takes nothing. If the plaintiff had won that case in Chamberlain and won $1 million, it would say final judgment. This case was tried. The jury awarded the plaintiff $1 million. Judgment is entered in the plaintiff's favor for $1 million. That's it. It's just long had to be a separate document. It triggers appellate deadlines, and it used to be extraordinarily confusing, and it used to be a lot of traps. They've made it much simpler. Nonetheless, the judgment is a critical document. We'll see when we get into appeals. So, as a practical matter, the winner of the verdict will prepare a judgment. It starts the timeline to file post-trial motions under Rule 50B and Rule 59. And it also, if you're the plaintiff, starts that clock, which means you're going to get your money sooner. Now, in the real world, there's insurance and settlements and all that, but that's if somebody doesn't have the resources that allows you to sell property. Yeah, if the thing didn't regrade, yeah, I can't fix Canvas. I'm not. I see, Shreya, your question. These aren't graded in that I'm tracking your points or anything. They're for your benefit. So if you got the answer right, that's all you need to know. And again, it was my fault this morning, but if it didn't regrade it correctly, it does not matter. And if you're watching later, you now know the answer to those 2 questions. What was the other? That was the other. Those were the questions I had from texts and emails and about the quiz itself. And then let me look on my phone. And then what I'll do is go through what I'm going to do next. Those of you who are, hang on, let me. What a mess. Hang on one second. I'm sorry. What I'm going to do next, for those of you who came a couple minutes late, is go through the March 30th. It's 03/30/20 final pretrial order and eve of trial slides. And by the way, again, I said this in email. This is voluntary. Stay as long or as short as you would like. But let me go through the questions. I imagine you're still seeing me when I'm looking at the PowerPoint. So if you see me like really close, that's because I'm old and can't see. I hope, by the way, I should have said, I hope you all are doing well. And I appreciate, I got some good notes about what y'all are what's working and not working on the PowerPoints and stuff. God, I would hate those. I was trying to think about. I was thinking trying to teach torts through this stuff, and it would drive me nuts. Okay, so I have on your own. I think there was more than just this. So if there's another one, but I'm looking at slide number 2 to 03/30/20 final pretrial order and eve of trial. So it says to amend a pleading, recall from Foman v. Davis as described in B, and figure out on your own who has the burden to show amendment should be allowed or denied, and write out the examples of when that is done, reviewing Beek's quote of Foman, and write it here. Okay, this is dealing with just the Rule 15 and its amendment under a pleading. And if you look at Beek, which God, seems like a long time ago, it is on. I hate the way all these civil procedure books suck. It's on page 438. The reason I was just answering a question on a listserv I'm on, and it's like one of those things. You guys know the answer to this. Do you file discovery, or do you just serve your discovery responses? You guys know the answer. Well, a Civ Pro teacher was asking why you didn't do it, and I was like, because there's a rule that says you don't. But I was nice about it. So if you look on page 440, it starts. The quote itself from Foman starts at 439. And what it says is that it quotes the rule. It says that permission to amend should be freely given when justice so requires. And then, so the way the rule is structured is the burden is on the party opposing the amendment. So if it's a complaint, which is usually what we're dealing with, the burden is on the defendant to show that it shouldn't be allowed to be amended. Okay, well, so what are the examples from Foman about when it shouldn't be allowed? And that's the top quote there. And it says, in the absence of any apparent declared reason. So that means the defendant has to come forward with one of these reasons. And it says, undue delay, bad faith, or dilatory motive on the part of the movement, repeated failure to cure deficiencies by amendments previously allowed. So I've got one is undue delay, bad faith, or dilatory means you're trying to delay motive. Repeated failures to cure deficiency, so they gave you a chance to fix the problem once before and you didn't. Number 3, undue prejudice to the party by virtue of allowing the amendment. And number 4 is futility. And we talked about futility. One of the things I mentioned about futility is one reason to oppose amending a complaint is that it would be futile. So let me give you an example of that. Suppose I want to amend my complaint to add a claim, and even if you take everything as true, it doesn't state a claim upon which relief can be granted. Well, what I would do as a defendant is we would talk first, confer, and I would say, I'm going to oppose your motion because it would be futile to allow it. If you're allowed to amend your complaint to add that claim, I'm going to file a 12b6 motion. And it'll end up that the judge grants it because even if what you allege is true, it doesn't state a claim upon which relief can be granted. So rather than go through all that, what I can do is oppose allowing the amendment because it will be futile. And basically, I argue my 12b6 in opposition to your motion to amend. So you would want to amend, and you'd file a motion for leave to amend your complaint. And you'd say, here's my new complaint, here's what I'm adding to it, and here's why it's a good thing. I'd write back and I'd say, under Foman v. Davis, there's 4 reasons why amendments should be opposed. One of them is futility. Allowing the amendment would be futile because it fails to state a claim upon which relief can be granted. So please just don't even allow the amendment. Otherwise, you're going to allow the amendment, and then I'm going to file a 12b6 motion. So that was to recall you to go back and think through that and look at your notes about particularly futility. But we also talked about how under Rule 41A, you get one free dismissal. You don't want to use that up unless you absolutely have to. Apologize, I blended 2 things. Under Rule 15, you get one free amendment within 21 days, and you don't want to use that unless you have to, because that might end up being one of the multiple times you tried to fix something and could not. So, and if you're the defendant, you want to make the plaintiff use that one free amendment up. And then I said, now read K9 Caviar, which is in the files, and Rule 16b4. Who has the burden to show a scheduling order should be modified and what is required to do so? Well, to modify a scheduling order, the burden is on the party seeking to modify it. So it's the opposite of a pleading, right? I have to, if I want to amend a pleading, it's on the party opposing the amendment to show it shouldn't be allowed. With a scheduling order, if I want to modify it, I have the burden to show good cause under Rule 16b-4 to show that it should be allowed, good cause. So now, why is that? Why is there the burden on the party who wants to change it? Well, remember, you sat down with opposing counsel and wrote down those dates that ended up becoming part of the scheduling order. So you agreed to them. And now you want to say that you shouldn't be held to the dates that you agreed to. And then I said, now the tricky part. Canine Caviar holds a deadline to amend pleadings in the scheduling order has passed. Good cause to modify the scheduling order is required. Now, suppose a court grants that motion and moves a date for amending pleadings to a future date. So I want to amend my complaint, but it's after the date in the scheduling order. So I file a motion and I say, please modify the scheduling order so that the date to amend pleadings is a month from now. Before that date, a party wants to amend its pleading and the other side does not consent. What must the party who wants its pleading amend its pleading do, and what is the burden that applies to the motion and who is the burden on? This is exactly the same answer as the first question. If I am seeking to amend my pleading and I still have the obligation to meet Rule 15a, I'm within the deadline for the scheduling order, right? So I don't have to change the scheduling order date now, modify it. But if you look at Rule 15, it says you can amend your pleading once within 21 days as a matter of course. Well, we're obviously way past that if we're changing dates in the scheduling order, because months have gone by at least. It says you can amend if the other side consents. This hypo says the other side does not consent. So now I'm back to, it says in all other circumstances, the amendment should be allowed when justice so requires, which is back to Foman v. Davis and the things we went through on the first part of that. So that's what that slide was designed to make you run through in your heads. Did y'all, I assume everybody else was still there, I think. Anyway, that was what the 3:30:20 slide number 2 was about. Hopefully I didn't cut out. So those are the things I had people send me questions about. And the key thing, and it'll get, when we do new trial motions, okay, 4-1. I knew there was another one. But on this new trial motion and judgment as a matter of law thing, you got to kind of stop and think and say, who would want a new trial? If I won and I won everything I want, including the amount of money, I don't want a new trial. I want judgment. If I lost, I want to argue, hey, 50B, make me the winner, but at least give me a new trial. And that's what we're going to turn to next. So just stop and think for a second and look at what happened in the trial and say, oh, okay, the person lost. So they're going to want to be made into the winner. But if not the winner, they're going to want to say there should be a new trial. If the person won, and again, everything, and we're going to see what won and lost means. There's nuances to it. We're not going to go real deep, but there's some complexity to it. If the person won, they're going to write up a judgment and get it over to the clerk so the clerk can enter it. So they're made the winner, and it starts the timing for the other side's motions. So yeah, you sent a text. Let me look. Oh wait, I see a bunch. On the if the record, a couple people and I've sent emails about this. Sometimes the recordings skipped and they seem to be different for different people. You need to look at the readings on it. I can't go back and try to piece together things. I will try to upload the PowerPoints. That's the best I can do. I don't know why sometimes the audio doesn't appear on the movie that it is on the PowerPoint, but otherwise you're going to have to do the reading on those. Okay, somebody said, can I explain one more time why you don't want the judge to grant a 50A? If the judge grants a 50A, it's going to be reversed if there is some evidence, more than a scintilla of evidence from which a reasonable jury could have found for the plaintiff. Again, it's almost always going to be the defendant doing this. Okay, so again, so that's where I'm at, and that's, I mean, if there is no evidence, great, I'll win on appeal. If there is just a tiny bit of evidence, it's going to get reversed, and I will have already gone through the trial and I'm defendant. I'm talking I've gone through this friggin' trial, and I've spent all that time and energy, and then the judge granted my 50A. If he just let it go, the jury was going to find my way. I'm winning. I'm kicking butt. Nobody's going to believe this Bainbridge dude at all. Instead, the judge grants my motion. Oh no. Now I have to argue there is no evidence for the other side. There is no way any reasonable jury in the world could have found for the plaintiff. And Bainbridge, I mean, the defendant won there, but again, if the judge had let it go to the jury, and if we're right about this Bainbridge's testimony, and if the reasonable jury would have said, well, no, there's no liability here, and they would have checked the box, defendant wins. Now on appeal, as the defendant, all I have to show is some evidence supports the verdict I won. Not that there's no evidence that the jury could have found for the plaintiff. And let me give you, suppose 900 people agreed with Bainbridge, 9,000 people agreed with Bainbridge. And I had one guy who said the two things never hit, and the jury came out my way. I win on appeal. Some evidence for which the jury could find for the defendant. So that it's just you are in a very difficult place defending the idea that there is no evidence. Now, let me back up though and give you an example where it would have been easy because of the law's definition. You remember our favorite case? What am I going to say? Yep, Haddle. Suppose they had tried Haddle, right? And at trial, and then again, go way back in time, Marrast says you need something more than an at-will employment contract. At trial, after the plaintiff is done with their case, I say, Your Honor, I move for judgment as a matter of law. There is no evidence from which a reasonable jury could find for the plaintiff because there is no evidence that he had anything other than an at-will employment contract. And the judge would say, oh, yeah, you're right. And I'd win. And I'd win on appeal, and I'd lose at the Supreme Court because they didn't change the law, they clarified the law. So there are some circumstances where it makes sense, but notice that's because there's this legal requirement in the law of a certain piece of evidence, and I simply do not have it. But hopefully that clarified it again. Showing a judge there's no evidence of something is really difficult. If you win, then all you have to show is some evidence supports the verdict, which you won. So you're in much better position. Someone's texted me a whole bunch of specific slides and I can't go over them right now. Let's see, from Backaways, I think. So wait, just want to reiterate. Oh, okay. So, okay, here's the question. So, if you didn't file a Rule 12 motion, okay, let me try to work through this. This is going back to Rule 12. So, look at Rule 12 and look at how it is structured. And as a sad comment on my life, I have it almost memorized. It says Rule 12B says any of the following can be in the answer. So great. So now I know I can just shove all this stuff in my answer, 12B 1 through 7. Or it says that the option of the pleader can be in a pre-answer motion. So, okay, now I know if I want to, I can make a motion that includes some or all of them. And we know that it has to be all of them that I have instead of putting in my answer. So now suppose I'm trying to think of how to answer this question in a way that I think answers it. Suppose that oh, I see what you're asking. Okay, so I file my answer and I leave out any one of them. It does not matter for purposes of this question which one. So I file my answer and I don't have any 12B stuff in there at all. Let me be really clear. I don't file a pre-answer motion. I file an answer. In my answer, I don't have any. I leave out all of them, and I have every single one of them. No, it's not a good. I have personal jurisdiction. Oh man, I screwed up. Under Rule 15, I'm allowed to amend my pleading once as a matter of course, and for answers, it's within 21 days. So now I can amend my answer, and I can shove in this court lacks personal jurisdiction. Remember, that's all basically I have to say is just state the defense that I have, not facts about. At least that's the way the law is right now. So within, if I haven't filed a pre-answer motion and I leave something out of my answer that's a Rule 12 defense, I can amend within 15 days to add it, and I didn't waive it. I think that answers that question. April 1st. Okay, so we did that one, and I apologize for all the clicking. And I hope you guys are doing okay. I mean, I know everybody's got their things. It's just kind of like, I feel like Job. The tornado warning the other day, I was like, seriously, tornadoes? Okay, hang on, I gotta find it. I apologize. And again, you're welcome to come and go April 1st. Hang on. All right. Oh, naturally, I pulled up. Hang on, sorry. Batman. Oh, okay, I know what I did. I cut it apart for the videos, and so the one I was looking at didn't have the first slides. Okay, here we go. All right, so I'm looking at, just so I'm at 040120 trial. I think I've made it so that the slide numbers match up, but I'm on what was slide number 2. It says pleadings. What does defendant, this should go pretty quickly, but this is good review. What does a defendant have to do in its pleading with respect to each allegation made? And the question, this says, can it simply allege in response to an allegation, I don't know what happened? And what language in the rule should the answer parrot, meaning repeat back, if it investigates and is still uncertain whether an allegation is true or not, or it concludes an allegation or complaint is partially true. So, and again, I have to apologize because this Rule 8, I don't remember off the top of my head, but let me be real clear. So what does a defendant have to do in its pleading with respect to each allegation? It has to admit or deny each allegation. And the key parts of Rule 8 that the Zelinsky case kind of dances around are in Rule 8B, 3, 4, and 5. Those are the ones that this slide is designing to have you look at. So can you simply allege, I don't know what happened? No, you cannot. If you look at Rule 8B, 5, it says a party that lacks knowledge or information sufficient to form a belief about the truth of an allegation must so state, and the statement has the effect of a denial. So with respect to that rule, if you look at the questions, it says, what if you investigate and you're uncertain, what language do you parrot? You parrot that. So to put this in context, I have an obligation under Rule 11B before I deny deny an allegation to do a reasonable factual investigation. So if I do a reasonable investigation and I don't know what the truth is, and I'll give a simple example. What if the allegation in your complaint is that you're a citizen of Ohio and I don't know? And I just don't know. Well, what would I put in my answer? You put paragraph 1, plaintiff is a citizen of Ohio. In my answer, I'd put paragraph 1, defendant, and I'm parroting the language out of 8B5. Defendant lacks knowledge or information sufficient to form a belief about the truth of this allegation, period. Right? Now, what a lot of people do is they'll say, defendant lacks knowledge or information sufficient to form a belief about the truth of this allegation and therefore denies the same. I don't have to actually say that last part because look what 8B5 says. It says the statement has the effect of a denial. So you can't just say you don't know, and what you want to do is just parrot that language. And again, that's what I do in my answer. I just copy that language and say it exactly as it is written there. That way I avoid problems with um, and actually, if you could resend your text, I don't necessarily see it, but I've got a lot of text there. All right. So then slide number 3, which says initial required disclosures. The stuff that you have to consider at the 26F conference is the stuff that's listed in Rule 26F. You submit a report as a result of it. And one of the things that you're supposed to discuss is ESI. So as a result, what do you have to do well before you confer? You need to understand what it is, how the ESI systems at your client works, for example. You have to think about the discovery that you're going to need, right? You have to think through how many depositions you likely will need, how many interrogatories, because remember, all of those things you are supposed to come ahead of time and agree upon to the extent you can in your 26F report. You have to think about a clawback agreement. Are you going to put something in the 26F report asking the judge to put in the scheduling order? There's not going to be any privilege waiver if there's an inadvertent production of privileged documents. All of the things that we have talked about much later. Remember how we did the course is we looked at 26F and I said, you guys don't even know what that stuff means, but you have to talk about it. We then went through it all and we went back to 26F and we went through in some detail and talked about what all of those things meant when it said limit depositions, limit or change the scope of discovery, address ESI issues. But there's a whole list of things in 26F. And again, just to be complete, often, and I referred you to the local rules. The local rules of a particular court will require that other things um, have to be in it. What discovery can be served at the 26F conference? You can serve your early request. There's requests for productions, but early requests for productions. No discovery can otherwise take place until after that, but those are allowed to be served. Why? The idea is that I can send you over draft requests for production and to let you know what I'm looking for, and you can do the same for me, and then we can figure out how our ESI is kept and all that. But even if we serve them before the 26F conference, they're deemed to be served as of the date of our 26F conference. So I would have 30 days after that to respond to them. And again, you and I can agree it's 45 days or whatever we want. What must each party disclose to the other even without a request early in the case? That's the stuff in 26A1, going from memory, A1, 26A1, initial required disclosures. And there's those 4 things. The witnesses that the party is likely to call to support a claim or defense, documents they may use to support a claim or defense. If you're the defendant, an insurance policy. If you're the plaintiff, documents that show how much damages there are and a calculation of them. And again, it is not every witness, it's those that you're likely to call. And so for your purpose, you want to just visualize a trial, and would you put that witness on the stand and say, tell us what happened? If they're going to say your client's a terrible person, that is not somebody you're going to call. If there's a document and it says your client committed fraud, that's not a document you're going to use at trial. So we can't get much past that kind of basic thing, but it is not all relevant documents or witnesses who know relevant information. The next slide, let me look back at the, partially true. Yeah, no, it is not. Thank you for the follow-up question. If you look at rule, and we looked at this with Zielinski, it's 8B3. Or wait, no, I'm sorry, 8B4. A party that intends in good faith to deny only part of an allegation must admit the part that is true and deny the rest. So Zielinski, this isn't that I don't know the answer, right? When I've investigated, I don't know, I use 8B5. 8B4 is you've alleged, let's remember Zielinski is you owned a forklift and the guy was your employee and he negligently drove it into my guy on a certain date. If the only thing that I really intend to deny in there is that I employed the guy, I need to say defendant admits that it owned the forklift and defendant admits that Mr. Zelinsky was hit. Defendant denies that Mr. Johnson was an employee of defendant and denies that Mr. Johnson was acting negligently at the time. So 8B4 is not that I don't know. 8B4 is you've made a mess of things and I have to go through and piece it apart for you. The one I was going to look at is 8B3 is saying basically is we talked about how you can never do this in federal court. I mean, I've never seen it done, which is nothing in the complaint is true. Or let me rephrase that. Your investigation gives you a Rule 11 basis to allege that nothing in the complaint is true. You can then just simply say defendant files a general denial, and that is just never done in federal court. State court, that is fairly common. Sorry, I'm having to bounce back and forth between this slide and the other one. All right, so wait, where am I? Okay, the slide number 4, it says discovery. Kind of hard to do all of these, but it says what are the purposes for and limitations on these, including whether they can be used to get from non-parties. The only ones that can be used on non-parties are requests for productions and depositions. And if you look at requests for productions, the last subsection of the rule says use a subpoena if you want them from non-parties, and somewhere in Rule 30 it says so for depositions. You can't use requests for admissions or interrogatories on non-parties because no rule says you can. Again, and to a little bit, there's lots of limitations on these apart from what I'm going to say, but this was designed to make you to go back and read both the specific rule, Rule 34, 36, 33, and 30, but also remember that Rule 26, G, is that right? Yeah, G, has a lot that applies to discovery about proportionality and proportionality relevant in a claim or defense. But to reiterate, requests for production are to get the party upon whom they're served, or a non-party if there's a subpoena used, to produce existing documents. And whenever I use the word document, I'm obviously not just meaning paper, things that can be perceived by human beings, even if it means using something electronic to perceive it. So a file or a tape, you name it. You don't create documents to respond to requests for production. You only produce stuff your client has. And again, requests for admission, those are very targeted questions. Admit that you owned the forklift. Admit that Mr. Johnson was your employee. Admit that Spain is in Europe. And they're targeted, they're useful. Remember also, if the party who receives them doesn't respond within 30 days, they're deemed admitted. And so you might say, admit that you ran the red light, admit that it caused me damages. And if they don't respond on time, you have these admissions now, which are binding on them for this particular case. Interrogatories are questions, right? Identify all persons with knowledge of relevant facts. Explain the facts supporting your contention that you were not negligent, or identify all facts supporting your contention that I was negligent. We talked about contention interrogatories and how those are very useful. Interrogatories are ways where you force the other side to write answers to questions. The limitation on them, besides that there is numeric limitation and there's a limitation of relevance and also proportionality, is that the practical limitation is that a lawyer is going to help write the answer. The client has to sign them, but a lawyer is going to help write the answer, so you're not going to get usually super juicy stuff. Depositions, apart from proportionality and relevance, the limitations are no more than 10 per side. Yeah, that's pretty much the only limitations on depositions. Why use a 30B6 notice? That is when you're an entity, a corporation, partnership sort of thing is on the other side, and you don't know who to ask the questions of, but also you really want to get its answers. 30B6 is the way you depose a thing, a corporation. And remember, the corporation then has the obligation to educate someone as to the facts and testify, and whatever that person says is the company's answer. So we talked about how I don't know is a really good answer if your question is, did you have safety policies in place at the day of the accident? If they say, I don't know, you now have the company saying they don't care about their workers. So the person who's presenting the 30B6 witness has the obligation to educate that person, take reasonable efforts to make facts known to or available. I'm trying to remember the language off the top of my head in 30B6. Have that person appear at a deposition, be asked questions, and that's as if the company is talking, or partnership and company. Um, why use a subpoena ducis tecum? A subpoena ducis tecum is how you get documents from a non-party. And we talked about how it's a just a fancy Latin phrase for it's a subpoena that wants somebody to give up documents. So that's what you would use. It's really you if you look up if you Google form federal court form for federal court subpoena is a fill in the blank PDF, and if you look at it, it says who it's to, why, and then it says please give me these documents, and it says attach a list. Well, what I do is I say all documents referring to the accident, all documents referring to your safety policies, all documents whatever it is I want, and I serve that on a non-party using a subpoena. But you should go look at it because it lays out. It says there's certain things it just lays out, and it's a form. And if you look at Rule 45 while you're looking at the subpoena, it'll all sort of match up and make some sense to you. Let me look it back and see if there's other questions. Yeah. And I'll look at my thingy here in a second. Let me check my texts. Can't talk. Oh, good. Somebody liked one of my answers. Whoops, I'm not looking at the thing I wanted to look at. PowerPoint. Experts. How do you determine whether a person will offer expert testimony? We talked about this only briefly, but remember that factual, because you don't know what Rule 702 says yet, but a fact witness is generally not allowed to give an opinion. So you want to watch for somebody giving an opinion about something. Fact witnesses are only allowed to testify about what they did, what they saw. They're not allowed to give opinions outside of something that you and I would be qualified to give an opinion about. Now, I can't test you very far on that, but you want to watch. If I say somebody's an accident reconstruction expert, somebody was a treating physician at the hospital, somebody is a plumber and is going to talk about how you properly put in a pipe, that's expert testimony. Because most of us, I mean, I know how to put in a pipe, but most of us don't know how to tell whether somebody has a broken femur or a bruised femur. We don't know how to figure out how an accident happened. It's going to be obvious to you that somebody's giving expert testimony. I can't play a lot of games with that, but you got to realize that, if the person is an expert, then you have to go to the next step, which is if they're going to testify. Now, notice that's an important part, right? If they're not going to testify, then they're a consulting expert, and it's hard to get to the opinions they have or the facts known to them. So how do you know if they're going to testify that they have to prepare a report? There's two categories that have to prepare a report. One is experts who were hired for the case, and it says retained for the case. These are your classic expert witnesses. After the case is filed, I realized they needed a doctor to testify about whether Mr. Cotret had asbestosis or not. I go hire somebody who that's their specialty. Those are the most common kind, if you will, of testifying experts. The second kind that have to prepare a report are as an employee of a party who regularly provides expert testimony. And one of the questions that I gave you on that review series of questions was about the person worked for somebody and they regularly gave expert testimony, but it wasn't a party. It was a garage the person worked for. No report from that person. They have to be employed by a party, and their job is that they regularly give expert testimony. If they have to give a report, what has to be in it? It's part of the required disclosures in 26A. I don't have it in front of me. 26, I want to say A3 or A2, but it says expert disclosures. What must be disclosed if she's a testifying expert, but not the kind who has to prepare a report? Now, let me look it up because it's all in 26, and I just can't remember what subpart. And notice they've got two things lumped in here. The initial Rule 26 says disclosures, and then it's got all this other kind of general stuff. I don't know why they did it that way, but they did. But if you look at Rule 26, yeah, A2, I was close. It says the report stuff is in 26A2B, I through little VI. And then 26A2C says, for what we're looking at now, folks who are experts, but you don't have to give a report, says if the witness is not required to provide a report, the disclosure must state the subject matter they're expected to testify and a summary of their opinions. So you have to provide, for example, the classic example would be woo, that wasn't good. The by the way, saved. That's common. Would be the treating physician at the hospital. So plaintiff's in a wreck, they go to the hospital. I didn't hire the doctor to testify, but that doctor is going to give opinions about what caused whatever it is that the doctor saw that day. That would be an example of somebody who is an expert, but I didn't retain him for the case, and it's a hospital. It's not me as a party, and their job isn't. Even if that doctor does testify all the time, that he works for the hospital, not for me, the plaintiff who was injured. So that would be an example of what you have to disclose for that kind of expert. Miscellaneous. What if a party wants to call a witness what if a party wants to call a witness not properly and timely disclosed as required, either as a disclosure or in response to discovery? Okay, so now we're at trial, and so I want to call a witness, and what disclosure is that referring to? That disclosure is referring to the final pretrial order, and maybe also expert witness, and maybe also 26A1 initial required disclosure. So they were not disclosed in that. They were also not disclosed in response to discovery. So I sent over a please identify all persons with knowledge of relevant facts, and there's no disclosure. This is going to require at minimum modification of the modification of the final pretrial order, because their person isn't listed on there, right? They were not listed on there, and they want to call them at trial. And the standard for modifying the final pretrial order is manifest injustice will result if it's not permitted. So that's very, very hard to show. And that's the Montefiore case that Justice Gorsuch wrote, right? Very, very hard to modify the final pretrial order. Because remember, we're now 90 days or so out from trial. Actually, we're less if we've filed the final pretrial order. If there's no scheduling order, 60 days out from trial. What does Rule 36 say if a party admits something at trial that it denied an answer? This was designed to force you to look more closely at Rule 36 to make sure you read through it. But it says basically you're going to get the money you had to spend to prove it up. And if you look at 36B, it says a matter. Wait. Where? Wrong one. Where is it? Oh no, it's not in 36. Gosh darn it! Hang on. It's in Rule 37. I hate everything in these rules. Here we go. It's 37C2. If a party fails to admit what is requested in Rule 36, and if the requesting party later proves a document to be genuine or the matter to be true, the requesting party may move the party who failed to admit to pay the reasonable expenses, including attorney's fees, in making that proof. That's 37C2. Sorry about that one. So Rule 36 doesn't say anything about it, is the answer to the real question. What risk arises if a party had disposed of ESI after the date on which it anticipated litigation for purposes of work product? Remember, both work product and ESI, the protection to avoid producing work product arises when you anticipate litigation, but you also have the obligation to avoid destroying documents or allowing document destruction to occur after you anticipate litigation. So the risk that you face is spoliation, that you will claim, oh, I don't have to produce this document because it's work product, But your client, after the date that you're of that document, will have been still destroying stuff. And when I say destroying, I mean they're just running through their normal. Hey, this document's 2 years old. We throw away stuff that's more than 2 years old. Your risk of spoliation. What is supplementation and what does it require? We talked about this. Every disclosure and every discovery response through one rule or another requires that the person making the disclosure or making the response supplement it. So if I initially give you my list of people I know about who I'm likely to call at trial to support a claim, and a week or two or a month or a year later I learn of another one, I have to supplement my disclosure if I find a new name. So what does that mean? So I send over something called plaintiff's supplemental initial required disclosures under Rule 26, and I put in a new name of somebody I'm likely to call. You have to do it in a timely fashion. Some of the rules use the phrase seasonably, but it's within a reasonable amount of time after learning about a new witness. I discover a new document. I learn of I get another bill in, a medical bill, so it goes to my damages. I have to supplement my initial required disclosures. I have to supplement maybe an interrogatory answer. It's not amending, but it's adding to your initial stuff, your initial disclosures. So hopefully that made sense. Number 7, jury. So how do you assert a right to a jury trial in a pleading? You just put jury trial demanded, like all of you did on your complaints. Otherwise, if you look at Rule 38, it allows you to file a demand for a jury. So you just file a thing called demand for jury. And I can't remember off the top of my head what Rule 38 says about the timing. It used to be 5 days after the last pleading. I think it's now 7, but you file this thing called a demand. So I file my complaint and I don't put jury trial demanded. You file your answer and you don't demand a jury trial. Either one of us has whatever that amount of time is to file something that just says demand for jury, and then we're going to get a jury. If the other side demands a jury and later seeks to withdraw that demand, but you want a jury, what do? Nothing. The Rule 38 says that a party cannot withdraw a demand for a jury without the other side's consent, to boil it down. So I can rely on your jury demand. So you file your complaint and it says demand for jury. I don't have to demand one of my answer. I do, but I don't have to. You later want to amend your complaint to delete the demand for jury. I can say, no, I want a jury. So we would end up with a jury there. And that's right. All that is in Rule 38 and 39. Number 8, recall Rule 15. Be sure you know how a defendant who hasn't filed a Rule 12 motion can plead a 12B defense omitted from its original answer. Okay, we just talked about that. So under Rule 15, remember, if I leave out a 12B defense in my answer, I haven't filed a pre-answer motion. I file my answer, I leave out 12B. This is dealing with that parenthetical. I can file an amended answer to add the 12B defense. How do I otherwise amend my complaint or pleading? As of right, I have within basically 21 days of the filing of the answer or Rule 12 motion. For an answer, I have the right within 21 days to file an amended answer. Otherwise, with the consent of the party, or I file a motion to amend with the court. And again, the rule says that you should allow amendment if justice so requires. So the party opposing the amendment has the obligation to show why it should be opposed. Scheduling orders, we kind of talked about this with Canine Caviar. We talked about all these things. What do I do to modify the deadline and amend a pleading? We went through that a few minutes ago with that slide on 330. We talked about the final pretrial order, and monophony is a good case for that. Summary judgment, we really have talked about this, but let me just again be real clear to make sure you understand. It says why, even though Rule 56 words are exactly the same, whether the plaintiff or defendant moves on plaintiff's claim, is a defendant far more likely to move for summary judgment. If I'm the defendant, I win summary judgment by showing there's no evidence, there's less than a scintilla of evidence on an element of the plaintiff's claim. If I'm the plaintiff, I don't win if I show some evidence on every element. Because remember, the words of the rule are no reasonable jury could find for the non-moving party. Even if there's some evidence on every element of the claim, the jury could say, well, whatever, but I don't believe that evidence, right? It's not enough for me to have some evidence. I have to have such overpowering evidence that no reasonable jury could find for the defendant. Now, it happens, but it doesn't happen that often. And I think I looked for cases where there were plaintiff summary judgment motions granted. I know I have some in my book, but they're hard to find because it's even though there might be a lot of evidence to support the plaintiff, that doesn't mean that the jury has to can't. I'm sorry, the jury cannot find for the non-moving party. What must the defendant do to show it's entitled to summary judgment? And again, this is on the plaintiff's claim. It must produce evidence from the discovery record showing the plaintiff has no evidence on one or more elements of its claim. It cannot simply say there is no evidence. It has to show there is no evidence. And we went through that with Celotex. After the defendant meets its burden of production in its motion for summary judgment, must the plaintiff do? It must file a response and produce some evidence on whatever element or elements of the case of its claim that the defendant has attacked. What language in Rule 56 shows that Rule 50 matters to Rule 56? It says there's no genuine dispute of material fact, and the movement is entitled to judgment as a matter of law. And Rule 50 is about judgment as a matter of law. And I think that got us through all of those things. And so we made it through all of those questions. So I don't know if you guys have another class or not. So text me more questions. I will get up next PowerPoints for next week, probably tomorrow, or yeah, tomorrow is Thursday. That's how bad it is. Please take care of yourselves. And I know this is probably happening with you guys too, but I'm like, every day is a blur. So Eliza, but it said that what if the defendant meets its burden of production? So let me deal with that question. The only time the plaintiff technically doesn't have to respond is if this would be the scenario I might give you. The defendant files a motion for summary judgment, and it says plaintiff has no evidence. I should get summary judgment. Okay, that's insufficient to meet its burden of production. Theoretically, I don't even have to respond as the plaintiff to that. But that question on that slide said, what if the defendant does meet its burden of production? What does the plaintiff have to do? But it is always good practice to, even if I see a motion for summary judgment and I know it should be denied because the defendant didn't meet its burden, I'm going to respond. And my first point is going to be, Celotex requires the defendant do more than say, you don't have evidence. It requires him to show I don't have evidence. Defendant didn't do that. Point two, there is evidence, and here it is. Point three, deny the motion. So I hope I answered that. But seriously, let me wrap up. Please take care of yourselves. I mean, I'm sitting here and I was like, when was the last time I was out of my house? It was like 4 days ago. And I was trying to remember where I went, what I did, and everything is kind of blurring in terms of days. And you guys, I can't, we're going to get a grading policy and final exam policy. I know what the committee is proposing, but until the faculty votes on it, I can't talk about it. What I'm going to try to do, my goal is I have two goals. I don't want to stress you guys out more than you need to be. I want you to years, and I want you to have a foundation for the rest of your careers, both within the law school and once you graduate. And unlike a lot of courses, this course is important towards that. I mean, I don't mean to demean the importance of what you the other stuff in other courses, but civil procedure matters for a lot of things. You'll run into this stuff in classes that don't really have anything to do with civil procedure because it just permeates things. So I'm trying to figure out a way that is a good way to grade and helps you in your short-term law school careers. And I think I have an idea about how to do that, and in a way that is fair and helpful and all those things. But until they vote and get the grading thing approved, I can't say any more about that, but I will as soon as I can. But believe me, especially there's some law schools that are not the best places to be right now. You're at a very good place to try to take care of everybody through this mess. And by the way, it is supposed to get real bad. So be very, very careful. And time, I swear I will have shaved, but it's kind of all gray and stuff. And then this Bozo the Clown shit's got to stop. So Be good, you guys. Text, email, and I may try Zoom. I understand it's been a bit of a hassle for some reasons, but everything has its pluses and minuses. Be safe, and hope you enjoyed the closet. Talk to you guys later.